Hi, and welcome to the Law Simplified. I'm Shaveen Bandaranayaka. This is a practical guide to learning tort law. In order to prepare, study, and then excel at the law of tort, it's important to understand and appreciate, on the one hand, how it fits into the grander scheme of the law, and on the other, the very breakdown of the syllabus and how you must tackle it one by one. Now, on the one hand, it's important to understand that tort law, by its operation, is essentially a hybrid between contract law on the one side and criminal law on the other. Now, as we had discussed in a practical guide previously for both contract law as well as criminal law, on the one hand, contract law creates a one-to-one relationship between individuals by choice, and the outcome of some sort of breach that may happen in relation to the obligations between the parties would be compensation, essentially a money transaction to put the parties back into the place they were before the contract was ever entered into. On the other hand, criminal law essentially creates a one-to-many relationship, not out of choice, but imposed on you by the state or the government, the breach of which is considered as committing a crime, and the outcome is punishment, either by virtue of a fine or imprisonment, or both. Tort law fits snugly in between. The reason why I say this is because, much like contract law, the outcome is that of compensation. There is a transaction that will take place for wrongs that have happened by the defendant. However, much like criminal law, this obligation to pay compensation is imposed on you by the law itself. Now, having understood and appreciated where tort law fits in terms of the grander scheme of the law at large, it's now important to understand and dissect the structure of this subject. By and large, tort law is made up of two constituent components, namely general negligence on the one hand and circumstances in which general negligence takes place. What do I mean by this? You can consider general negligence as the building blocks or the foundation of tort law. It creates the imposition of the duty, which, if breached and causes the harm, means that based on the circumstance, there'll be a specific type of tort that's applicable. Now, establishing general negligence in itself is quite a sequential event. Firstly, you need to establish that the defendant owed a duty of care to the claimant or the victim in this case. Duty of care is something that the law will impose on you, but, and this must be stressed quite a lot, duty of care alone does not equate to negligence. Now, duty of care can be one which is pre-existing, things which we are familiar that parties should owe a duty of care between one another, such as a doctor and a patient, a parent and a child, a lawyer and a client for that matter. Certain instances might fall under novel categories, which there are tests to go over as well. Once duty is established, we need to move on to determine if that duty has been breached, or in other words, if the defendant has acted below the reasonable standard expected of a person in his or her capacity. If this is fulfilled, we move on to the next step, which is causation. Can the actions of the defendant be considered either the sole act or the act that materially increased the harm in relation to the claimant or the victim? Once all of this is fulfilled, we have to also make sure that the injury or the damage or the loss suffered by the claimant was not too remote in the sense that it's unforeseeable by the defendant. These four primary indicators or these four primary requirements being fulfilled, you have what we call general negligence in relation to the defendant. Now, based on the circumstances between these parties, the type of negligence will differ from defamation to occupier's liability, to vicarious liability, to nuisance, or the rule in Rylance and Fletcher. So for instance, if the defendant had negligently said something which harmed the reputation of the claimant, that will be categorized under defamation as a claim. If, for example, the defendant is an owner of a particular property or a controller of a particular property, and due to the negligence as specified by the law, either a trespasser or a visitor is injured, dies, or has simply property damage, this might be categorized under occupier's liability. If the negligent actions of the defendant unreasonably interferes with the enjoyment of his neighbor's property, this may be categorized as nuisance, for instance. If that goes on to cause damage, for instance, due to the unnatural use of the defendant's land, we might categorize that within the rule in Rylance and Fletcher. Now, these two constituent components in place, namely, on the one hand, understanding what sort of liability accrues in terms of a defendant, and then coupling that with the type of negligence that has been established by pragmatically going through each individual step and then identifying the circumstance in which this has manifested itself, either by virtue of occupier's liability, defamation, nuisance, or even vicarious liability at that, we are able to properly tackle a question that is presented in relation to the law of tort. Right, that was a practical guide to the law of tort. If you'd like to set up a one-on-one fast track or a masterclass program to dive deeper into the subject matter of tort, make sure you reach out through the links in the description below. Make sure you have a look at the comprehensive pre-recorded fast track and masterclass programs as well, available on the online law school platform, which you can access through the link that will appear on screen right now. But until the next time that we meet, have fun, stay safe, and as always, obey the law.